Okay. So, some Supreme Court cases. There's Marbury versus Madison. This happened in 1803. This is actually probably one of the biggest court cases in history because it set the precedent or the tradition of judicial review. Congress prior to this did not have the authority to send the case to the Supreme Court because they had questions of jurisdiction. But what this case did was it established that the Supreme Court could review any court case and then rule it either constitutional or unconstitutional. If you really want to know what the case is about, it was Thomas Jefferson versus James Marbury. Marbury was a judge who got appointed by John Adams, who's the president before Jefferson. And when Jefferson took office, Marbury hadn't received his letter to become a judge. And so Jefferson was like, don't send them to him, even though he had gone through the correct process of getting approved by the Senate. So the court ended up ruling that Marbury had a right to be the judge because he had gone through the proper processes and should be the judge. But again, the biggest thing to remember, this establishes judicial review where the courts can overturn a law if it is unconstitutional. McCulloch versus Maryland. State can't tax the Bank of the United States. Maryland had a tax against the U.S. Federal Bank. I believe it was the second federal bank. And the ruling was that state government can't tax federal government because federal government is above state government. So it goes with the supremacy clause that the national government is the largest, is the biggest, and federal government is over state government. Gibbons v. Ogden ruled that the national government controls interstate trade. What happened, this was in New Jersey, New York, they were trying to set a monopoly on the waterways. If I remember correctly, Ogden is the group that had a contract with New York and New Jersey, and they were the people that if you wanted to get on the waterway, you had to basically apply with them and get their permission. But what the Supreme Court ruled is that waterways are essentially interstate. They are ways to go up and down between states, just like our interstate system is now on the road. So they aren't controlled by an individual. They are controlled by the federal government. And since they're controlled by the federal government, it's open to everyone. Scott versus Sanford, we've actually talked about this one a little bit. This was the ruling in 1856 that slaves are not citizens. Scott's owner had passed away, so after he passed away, he sued for his freedom, saying that he should be free since his owner had died. And then again, the Supreme Court ruled that since he was a slave, he could not bring the case to court, and that was the ruling they made. Plessy v. Ferguson, we've also talked about this one. They ruled separate but equal was constitutional. Homer Plessy got on a white train car in Louisiana, took it to court. In the local courts, he lost, and then when he took it to the Supreme Court, they thought it would be overturned, but the Supreme Court decided that as long as they were separate but equal, it was constitutional. We know that later on this gets overturned with Brown v. Board. Okay, Schenck versus U.S. This happened during World War I, right after World War I. The ruling is that clear and present danger doctrine overrules the First Amendment rights. Schenck was a socialist who was avoiding the draft campaign. He printed out like 15,000 flyers to then pass out and encourage others to not register for the draft. And so they basically said that he was inciting a riot. There was clear and present danger. And so therefore, it was not unconstitutional for his First Amendment right to be overruled and for him to suffer consequences for what he was doing. Korematsu versus U.S. This one's really interesting. It's one of the only ones that gets overturned and actually had an official apology issued, but the official apology was like almost 7 years later. So this happened during World War II after Pearl Harbor. The ruling during 1944, is that rights may be denied during crisis/military necessity. What happened was President Roosevelt, who was our president during World War II, issued an executive order, said that if you were a Japanese American or if you were of Japanese descent, you had to go to detainment camps, kind of like the way that Germany forced Jews into internment camps. The only difference is, we didn't gas people, but it was a way to segregate. But later on, I believe in 1983, they end up overturning the decision. They go back and say that it was unconstitutional. And then in 2011, there was actually an official apology issued by the Department of Justice. Brown v. Board was happened in 1954. This is the ruling that goes back and states that separate is not equal. It overturns the Plessy v. Ferguson case. And it says it's unconstitutional under the 14th Amendment because under the 14th Amendment, every citizen has equal protection under the law. Gideon versus Wainwright, this is the one that secures the fact that everybody has a right to an attorney. And this is based more on the Sixth Amendment, but the Fifth and Sixth Amendments, because Fifth and Sixth Amendments deal with due process and a fair trial. So if you go to court, you must have an attorney, or if you do not find one will be provided for you. That's part of the Miranda rights that you hear when you're being arrested, and that is to inform you that if you do not have an attorney, one will be appointed to you by the state. This happened in Florida, I believe, and he was arrested, sentenced to jail, but was never represented in court by an attorney. Mapp v. Ohio, this lady's home was searched without a warrant, and there was no clear and present danger. There were no gunshots heard. It was done off of a tip that they knew that some illegal activity was being done there, but they never went and got a warrant. So since they never went and got the warrant, none of the evidence they found in the house could be admissible in court. So basically, she got off even though she was doing something wrong. And this is, again, why the process is so important of getting a warrant, going through due process. But she went to court saying that her Fourth Amendment right of illegal searches and seizures had been violated, which it was because no warrant had been issued and there was no clear and present danger. The cops had no reason to search her home other than to go off on the tip that illegal activity was being done there, but not life-threatening illegal activity. Worcester v. Georgia. This happened in 1832, and this one is really interesting because it shows the relationship between how everything is supposed to work together between three branches. Okay, so in Georgia, this is around the time of the Trail of Tears. A lot of Cherokee Indians were being forced off their land and onto the Trail of Tears to move to reservations. And a group of Indians or a group of Native Americans got together, put a lawsuit together, and took it through court. In Georgia, it was ruled that they had no right to keep their land, but when it went to the Supreme Court ruled that it was unlawful and unconstitutional for them to be kicked off their land or have their land taken from them. So the court made the rule that they had a right to keep their land, but Andrew Jackson, who was the president at this point, has a pretty famous saying. He said, "You have made your decision, now enforce it." And if you remember from our branches of government, the judicial branch just makes the decisions. The executive branch enforces it. So, and you'll see this happen again about 130 years later during civil rights, where the court makes decisions, but a lot of times the executive branch may be 15 or 20 years catching up to the decision. Everything has to work together. If they don't work together, then the judicial court can make a decision, but if the executive branch doesn't enforce it, it really doesn't change anything. Okay, Olmstead versus U.S. This ruling ends up getting overturned later on by another court case in the 60s. But during the 20s, there was something called McCarthyism. That's where we were really scared of communism and scared of people being communist. So the court made a ruling saying that the Fourth Amendment of unreasonable search and seizure did not apply to wiretaps. So people could listen to what people were saying on the phone, and that was considered okay by this court case. Engel versus Vitale. The ruling is government-directed prayer, even if neutral, is a violation of the First Amendment. So if there's any prayer on public property, it has to be led by someone who is not a government official, aka anyone who is not a government employee. So if students were to pray, that is okay, but a teacher could not lead the prayer. This came about because there were groups of families in New York who were parts of other religious groups other than Christianity, but Christianity as well was being prayed in school. There's Miranda versus Arizona. The ruling, the suspects must be read their rights upon arrest. This is why you hear you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, won't be provided for you. Those are your Miranda rights. Those came about because of this court case, named after this guy, Miranda. So the rights that get read to you are for the Fifth Amendment of self-incrimination. You have the right to remain silent, and the Sixth Amendment right of you have a right to an attorney. Now, this man was convicted of rape and kidnapping, but it was overturned in this case because he wasn't read his Miranda rights. Doesn't matter if he did it or not, the due process wasn't followed, so he was declared a mistrial and was able to get off. In Gault, the ruling here is that juveniles have the same fundamental basic rights as adults. It was a lewd phone call or vulgar phone call. The kid was sentenced to 6 years in juvie, a delinquent home, but the decision was overturned because, again, he had the same fundamental rights as an adult, and the due process wasn't followed. Tinker versus Des Moines, you remember reading about this one. Students have limited free speech at school. So free speech can be limited, again, if there's clear and present danger. But again, with this one, they're wearing black armbands. There was no clear and present danger. They were not inciting a riot. Therefore, it was not unconstitutional. They had the right to do it. Roe v. Wade, this is one of the most debated court cases in history. It's the right to a limited abortion period. This is what's established like trimesters and when someone can have an abortion. Also, the right of a woman to control her own body. This falls under the 9th Amendment, which gives, again, the rights that aren't in the first 8 amendments to individuals, the people, and the 14th Amendment, which is equal protection under the law. Also sets up the question of when is a fetus a legal person, because if abortion is technically murder of a legal person, if that fetus is a person, so then it sets up the question of when is a fetus a legal person, which again is why this is such a debated topic. Furman v. Georgia, this is in 1972. It's the ruling that the death penalty is unconstitutional against the 8th Amendment because of cruel and unusual punishment. And what they found is that in a lot of death penalty cases, there was racial imbalance. So there was some discrimination. So the court ruled that Furman could not be sentenced to death, even though it was a murder trial. And this pretty much put an end to the death penalty. And again, during the 70s, you have to remember electrocution was the form of the death penalty, and that was seen as cruel and unusual punishment. The way they kind of got around this later on was lethal injection. Okay? And that's deemed a more humane form of the death penalty. Here are some in North Carolina. Swann v. Charlotte Mecklenburg. This is actually a fairly recent ruling. Happened within the last 10 years, I believe. It's forced busing of schools to desegregate held as constitutional. So there were people who wanted Charlotte Meck to not bus kids as far because there were kids who were having to spend an hour and a half to 2 hours on a bus when they lived 5 minutes from another school, and they'd be bused to a school farther away in order to diversify the schools because the neighborhoods would be very largely one population or another. So in order to have diversification, they bused kids from different neighborhoods to different schools. So that way there would be a little more diversity. So the court case came up and the Supreme Court upheld the ruling of the busing because it was a form of desegregation and making things more equal. You also have New Jersey versus TLO. The right of schools to search students under reasonable suspicion. There were 2 students smoking in the bathroom. They searched one of the girls' purses and produced evidence of marijuana. She claimed that her 4th Amendment right had been violated because there was no warrant. But if you remember what we talked about earlier, where there being reasonable suspicion, if you see somebody smoking who's underage and then search their stuff, it's just like if I were in my truck and I were smoking and the cop walks by and smells pot, he has reasonable suspicion then to get me out of my truck and search my truck if he believes that I am under the influence of marijuana. Okay. So it kind of established that when you're on school grounds, if you give reasonable suspicion, then people at school have the right to search your things with or without a warrant. California versus Bakke. This is an interesting one. It was a ruling of racial quotas for minority students. It ruled that quotas for minority students is unconstitutional. Gosh. So Bakke is this guy who wanted to go to med school. He applied twice and didn't get in, even though his credentials were higher than some students who did get in, but were minorities either of African American or Latino descent. And so he took it to court. The court ended up ruling that it was unconstitutional for them to have quotas on making sure they hit certain numbers for minority students, but they did not force the school to admit Bakke. Hazelwood Schools versus Kuhlmeier. This happened in 1988. The ruling was it was the right of schools to limit free speech within the school paper. The school paper was putting things in that were of personal natures like divorce, pregnancies, and that kind of stuff. So the Supreme Court ruled that those things don't have a place in the school paper. It has to fall into some school goal and not under some personal matter. So basically, what is proper and not proper for a school newspaper. Texas v. Johnson. This is also a debated topic, debated court case. It ruled that flag burning held as a form of constitutional free speech. So a man in Texas burned a flag in protest of President Reagan's policies. He was arrested and then went to court. They ruled that he did not incite a riot. There was no clear and present danger. Therefore, this was just another form of free speech. This one is also from North Carolina, Leandro versus State of NC. It actually involves the county that I'm from, or one of the counties. I'm from Vance County, and Vance County is one of the 5 counties. It was Hope, Cumberland, Vance, Robinson, and maybe Hunt, but Halifax, my bad. Hope, Halifax, Cumberland, Vance, and Robinson. Those are the 5 counties that basically said that everybody has the right to a sound basic education. Essentially, there was a lot of inequality in education in North Carolina based on funding and poverty levels. So they were claiming that North Carolina needed to remedy that. The Supreme Court agreed, and it's actually gone to the Supreme Court twice, and both times the Supreme Court has upheld the decision that North Carolina should make educational environments more equitable. However, we really, again, kind of what we were talking about earlier, it's not like it's a magic switch. We're working towards it, but it still has not quite gotten there yet. State versus man, that's happened in North Carolina as well. It was slaveholders can be prosecuted for attacking the enslaved. The case goes to the court after a slave is beaten by someone he is loaned out to and not the owner.